All right, today we are digging into a truly incredible story, one pulled straight from the archives of international law. It's all about how two nations try to do the impossible, use a piece of paper to stop a superpower's nuclear weapons program in its tracks.
I mean, really think about that question. How do you do it? Well, that was the exact problem at the heart of this wild legal showdown back in 1973. It was a clash that put the world's highest court up against the raw power of a nuclear-armed nation.
So our story kicks off in the South Pacific. You know, picture-perfect paradise, right? Well, not exactly. Something was seriously poisoning that paradise. France was running a series of atmospheric nuclear tests, and for all its neighbors, the radioactive fallout was quickly turning from a concern into a full-blown crisis.
So, on May 9, 1973, Australia decided it was time to fight back. But not with warships or soldiers, nope. They decided to fight back with words, written on a legal document. They went straight to the International Court of Justice with a demand that was incredibly direct and aimed right at the heart of France's nuclear ambitions.
But here's where things get really strategic. See, Australia wasn't going in alone. This wasn't just one country filing a complaint. This was a coordinated legal assault from an entire region that had had enough. On that exact same day, New Zealand filed its own, almost identical lawsuit against France. What you're looking at right here are the official documents. Just imagine the scene, two different countries in perfect sync taking one of the world's biggest powers to court. Now, their arguments were really similar, but each had a slightly different focus. Australia took a broad approach, basically arguing that these kinds of tests were just flat out inconsistent with international law. New Zealand, on the other hand, was much more specific, pointing to the radioactive fallout landing on its territory as a direct violation of its national rights. And the momentum was building fast. The very next day, the nation of Fiji filed to join the case too. This just goes to show you this wasn't some minor dispute. This was a huge issue for the entire Pacific region.
Okay, so you've just done the unthinkable. You've sued a global superpower. The billion-dollar question now is, how are they going to react? Are they actually going to show up and defend themselves?
And this really became the central issue. See, international law often depends on countries actually agreeing to participate. France had a choice to make, and its decision was going to define this entire conflict. And their answer, when it came, really boiled down to these two words. This was it. This was the core of their entire argument, the shield they were about to raise against the court. On May 16th, the French ambassador sent a letter. It said the court was, and I'm quoting here, manifestly not competent. And why? Because when France had agreed to the court's rules years before, they had included a critical exception for anything related to its défense nationale, its national defense. And for France, its nuclear program was the very definition of national defense. So France's position was just a total, absolute rejection. They weren't just going to argue their case, they refused to even play the game. They wouldn't appoint a lawyer, they wouldn't show up, and they basically told the court to throw the whole thing in the trash. It was a complete boycott. This whole situation just set the stage for an incredibly fast and super tense standoff. You had France refusing to play by the rules, but the court wasn't backing down either. And just look at how quickly all of this went down. May 9th, the cases get filed. Just 1 week later, on the 16th, France says, no way. And then, only 5 days after that, the court plows ahead anyway, opening public hearings to decide whether to issue an emergency order to stop the tests. So, the hearings went on. You had lawyers for Australia and New Zealand making these urgent, passionate arguments, and all the while, the chair reserved for the representative from France just sat there, completely and pointedly empty. After the hearings, the world was basically holding its breath. Was the International Court of Justice actually going to dare to issue an order against an absent, defiant, and very powerful nuclear state? The answer came on June 22, 1973, and wow, it was close. By a razor-thin vote of just 8-6, the judges decided to act. That tiny margin tells you everything you need to know about just how contentious and unprecedented this whole situation really was. So what the court did was issue something called provisional measures. The best way to think of this is like a temporary restraining order in international law. It's an emergency action designed to stop a situation from getting worse while the main case is still being sorted out. The order itself was very cleverly written.
First, it directly told the French government to avoid any tests that would cause fallout on Australian territory. Second, it told both sides to just cool it and not do anything to make the dispute worse. But that third point was absolutely crucial. The court stressed that this emergency order did not mean it had made a final decision on whether it even had the power to judge France in the first place.
So what we're seeing here was really just round one. The court had essentially hit the pause button. It set deadlines for later in the year, getting ready for the ultimate legal battle over that fundamental question. Did the court even have the right to tell a superpower what to do? The real fight was still to come. And that leaves us with the big question that still echoes through international law today. The court issued its ruling. It flexed its legal muscle. But what happens when the moral authority of the law goes head-to-head with the raw power of national sovereignty? Put simply, can a court with no army truly compel a nation with a nuclear bomb? That's the challenge this case forces all of us to consider.